On July 4th, 1776, members of the Second Continental Congress signed the Declaration of Independence. This historic document declared our independence from England under the rule of King George III. The 13 colonies announced to the world that they were now 13 free and independent states. The Congress then decided to draft a framework for a new government. The end result was the Articles of Confederation. Congress adopted the Articles in November of 1777, but final ratification or approval from the 13 states did not take place until March of 1781. The Articles of Confederation, however, proved to be a weak and ineffective form of government. It allowed for only one legislative body, or Congress, composed of representatives chosen annually by their state governments. Each state was only allowed one vote in Congress, regardless of population. The Congress was given no power to tax or control commerce. There was no independent judicial or executive branch to enforce laws. These restrictive powers were taken in order to prevent the central government from becoming as powerful as England and their king had been while governing the colonies. The new government was clearly in trouble, and a new course of action was desperately needed. In September of 1786, two important leaders of the new nation called for a convention in Philadelphia the following May. These men were James Madison of Virginia and Alexander Hamilton of New York. The goal of this convention was to make important changes to the Articles of Confederation. The end result, however, would produce the United States Constitution, a framework for democracy that has lasted over 200 years. The Constitutional Convention took place between May 25th and September 17th in 1787. Of the 13 states, all but Rhode Island sent delegates. There were 55 delegates in all. On the first day, George Washington was elected president of the convention. Washington had been general of the Continental Army during our War for Independence from England. He was considered the most loved and admired man in America. Edmund Randolph of the Virginia delegation offered the convention 15 resolutions which became known as the Virginia Plan. This plan would create a new central government with a two-chambered Congress, an executive elected by the Congress, and a judicial branch. Representation in the Congress would be based on each state's population. Delegates from the smaller states were quite concerned over this issue. They supported the New Jersey Plan proposed by William Patterson. The New Jersey Plan kept the Articles of Confederation, which gave the states equal power in the Congress, but added a Supreme Court. Debate on these two plans continued until mid-July, when Roger Sherman from Connecticut offered a compromise. His plan called for a two-chamber Congress. The lower branch, called the House of Representatives, would be proportional to the population of each state, and its members would be directly elected by the people. The upper branch, called the Senate, would contain an equal number of representatives from each state. The members of the Senate would be chosen by their respective state governments. There would be an executive branch headed by a president. The president would be elected by an electoral college composed of people chosen by the voters of each state. The electoral votes of each state would be equal to the number of its representatives and senators. The candidate with the second highest vote in the electoral college would become vice president. If no one received a majority of votes, the House of Representatives would choose the president, with each state allowed one vote. The convention also agreed upon the formation of a Supreme Court. The delegates believed that this three-branched form of government with a legislative, executive, and judicial body would serve the American people well. The Constitution also included a series of checks and balances between the three different branches, which assured the public that this new government would not and could not become as tyrannical as England and its king had been. On September 17, 1787, after 3.5 months of debate and compromise, the United States Constitution was signed by 39 of the 55 delegates. The convention sent the Constitution to the Continental Congress, which, in turn, submitted it to each of the 13 states for approval. There was much opposition to the new Constitution, but most of it subsided when James Madison and his followers, called Federalists, pledged to add amendments guaranteeing the civil rights of the people. These became known as the Bill of Rights. A majority of the states approved the Constitution by 1788, and a new form of government was born. In 1789, the first elections for the House of Representatives and the Senate were held. It was also at this time that the electors cast their ballot for the nation's first president. By a unanimous vote, George Washington was elected President of the United States. John Adams was elected Vice President. The inauguration took place on April 30th, 1789, in our nation's first capital, New York City. With Congress passing the Judiciary Act of 1789, the Supreme Court was established, headed by Chief Justice John Jay. By December of 1791, the Bill of Rights were added to the Constitution. These 10 amendments are the cornerstone to individual freedom in America. Over the past 200 years, the Constitution has been amended 27 times. These changes were deemed necessary to keep the Constitution functioning properly in an ever-changing world. Our founding fathers had the foresight and wisdom to know that the Constitution must remain a flexible and living document. The First Amendment states that the government cannot interfere with a person's right to freedom of speech, freedom of the press, freedom of religion, freedom of assembly, and the right to petition their leaders. The Second Amendment guarantees a citizen's right to bear arms. The Third Amendment forbids the government from housing soldiers in private homes. The Fourth Amendment offers citizens freedom from unwarranted search and seizure of their papers and property. The Fifth Amendment guarantees against being tried twice for the same crime, self-incrimination, and the loss of liberty or property without due process of law. The Sixth Amendment gives people who are accused of crimes the right to a speedy and public trial by a jury of their peers, to know their accusers, and have a lawyer defend them. The Seventh Amendment gives people involved in lawsuits over money or property to the right to a trial by jury. The Eighth Amendment provides protection against excessive bail and cruel and unusual punishment. The Ninth Amendment states that the fact that some rights are not specifically mentioned in the Constitution doesn't mean that people do not have them. And the 10th Amendment states that any powers not given to the government by the Constitution belong to the states and to the people. The 11th Amendment was designed to keep lawsuits between the states and their citizens out of federal courts. The 12th Amendment clarified the procedure for the election of the president and redefined the role of vice president in relationship to the presidency. Following the Civil War, 3 amendments were added to the Constitution. The 13th Amendment abolished slavery and involuntary servitude. The 14th Amendment provided civil rights to all former slaves, And the 15th Amendment declared that the right to vote was not to be denied on account of race, color, or previous condition of servitude. In the beginning of the 20th century, during a period of growth called the Progressive Era, 4 more amendments were added to the Constitution. The 16th Amendment allowed for a federal income tax for revenue to the ever-expanding federal government. The 17th Amendment allowed for the election of United States senators by the people and not by state governments. The 18th Amendment forbid the drinking and selling of alcohol. This was known as prohibition. The 19th Amendment finally gave women the right to vote. The 20th Amendment shortened the period between the election of the president and his inauguration. The date was changed from March 4th to January 20th. The 21st Amendment repealed the 18th Amendment, allowing, once again, the drinking and selling of alcohol. The 22nd Amendment limited the president to 2 terms in office, not exceeding a total of 10 years. The 23rd Amendment gave the residents of Washington, D.C., our nation's capital, the right to vote for president and vice president. The 24th Amendment abolished the use of a poll tax as a requirement for voting in federal elections. The 25th Amendment provides for situations of presidential disability and ensures that any vacancy in the office of vice president is filled. The 26th Amendment lowered the voting age from 21 to 18 years old. The 27th Amendment was first proposed by James Madison in 1789. It was finally added to the Constitution in 1992. It prohibits midterm changes in the salaries of the members of Congress. As stated earlier, the Congress is composed of a House of Representatives and a Senate. Members of the House of Representatives are chosen by popular election in the states every 2 years. The representative must be at least 25 years old, a citizen of the United States for at least 7 years, and must live in the state in which he or she is elected to office. The Constitution allows for a census of the people to be taken every 10 years to determine the number of representatives allowed to each state. No absolute limit was placed on the number of members of the House, but in 1913, Congress limited the membership to 435. Vacancies in representation from any state are filled through special state elections. Members of the House of Representatives choose a speaker and other officers to conduct the business of making laws. They also have the sole power of impeachment. Impeachment is a formal charge against a public official, like the president, for misconduct in office. The Senate is composed of 2 senators from each state. Each serves a term of 6 years. Senators must be at least 30 years old, be a citizen of the United States for at least 9 years, and live in the state in which he or she is elected. The Vice President of the United States is the President of the Senate, but has no vote except when it's necessary to break a tie. Members of the Senate choose their officers and also a President pro tempore. This is a senator who fills the position of President of the Senate when the Vice President is absent. The Senate has the sole power to try all impeachments. If the President of the United States is impeached by the House of Representatives, the Senate would hold a trial to determine guilt or innocence. The presiding judge would be the Chief Justice of the Supreme Court. A 2/3 majority of the Senate is needed for a public official's removal from office. The House of Representatives is responsible for all bills of revenue. That is, they hold the purse strings of the United States. The Senate, however, can propose amendments to these and other bills. Every bill approved by Congress must be presented to the President of the United States before it becomes law. The President can sign the bill into law, or he can veto the bill and send it back to Congress. Veto is a Latin word meaning "I forbid." Without the President's signature, a bill can only become law if 2/3 of both the House and the Senate vote in favor of the bill. The Constitution states that Congress has the power to lay and collect taxes to pay debts and provide for the common defense and general welfare of the United States. They also have the power to borrow money on credit of the United States, to regulate commerce, to coin money, to establish post offices, to declare war, to raise and support an army and a navy, and to make all laws which they believe to be necessary and proper. Members of Congress are paid for their services, for they are not allowed to hold employment outside of the House and the Senate. The executive branch of the federal government is headed by the President of the United States. As we told you earlier, both the President and the Vice President are elected by a system known as the Electoral College. The President must be a natural-born citizen of the United States, at least 35 years old, and be a resident in the United States for at least 14 years. The President is paid for his services to the United States, for he is not allowed to hold any other office while serving the country. Before he can take office, he must take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of the President of the United States, and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. The President is elected to a term of 4 years and is allowed to serve 2 full terms in office. The President is the Commander-in-Chief of the Armed Forces and has the power to grant reprieves and pardons for offenses against the United States. The President can also make treaties with other countries, appoint ambassadors and federal judges. All of this can be done, however, only with the approval of the Senate. The Constitution also requires that the President give to Congress from time to time a report on the state of the Union. The Constitution also states that the President, Vice President, and all civil officers of the United States can be impeached and removed from office for treason, bribery, or other high crimes and misdemeanors. This lets all Americans know that no one, not even the President, is above the law. Once the President is in office, he chooses a cabinet. This is a group of people who advise the President on a number of issues. Currently, there are 14 cabinet members, known as secretaries, who head these government departments: the Department of State, the Interior, Labor, Agriculture, Commerce, Defense, Education, Energy, Health and Human Services, Housing and Urban Development, Transportation, the Treasury, Veteran Affairs, and the Justice Department. All of these people are appointed by the President but must be approved by the Senate. The writers of the Constitution created the office of Vice President so that someone could automatically serve as President if the Chief Executive died in office or resigned. The Constitution gives the Vice President only 2 duties: to be the President of the Senate, where he can only vote to break a tie, and to help decide when the President is too disabled to perform the duties of his office. The President and his family live at 1600 Pennsylvania Avenue in Washington, D.C., a residence known simply as the White House. Throughout our nation's history, there have been many great men that held the office of President. They include George Washington, Thomas Jefferson, Andrew Jackson, Abraham Lincoln, Theodore Roosevelt, Woodrow Wilson, and Franklin Delano Roosevelt. When a new president is elected and we witness the peaceful transition of power from one political party to another, we see the Constitution at work. The judicial branch of our federal government is headed by the Supreme Court. Its decisions in civil and criminal cases are final. The justices are appointed by the President and approved by the Senate. Those who serve on the court serve for life unless they are removed from their position for serious offenses. They are paid for their services, for they cannot hold any other office while serving on the court. They have the power to decide whether a law is constitutional or not. And since 1869, there has been one Chief Justice and 8 Associate Justices on the Supreme Court. The court's regular session starts on the first Monday of October and usually ends in midsummer the following year. The court, however, can hold special sessions whenever they deem it necessary. After they hear a case and a majority vote has been reached, they write an opinion on the case. This is a document that announces the decision and the reasoning behind it. If some of the justices don't agree with the majority, a dissenting opinion is also written, stating why they disagree with the majority. The Supreme Court has the authority to decide what is and what is not constitutional. This is called judicial review. Some of its more notable Chief Justices have been John Marshall, who was known as the Master Builder of the Supreme Court; William Howard Taft, the only president to ever serve on the Supreme Court; and Earl Warren, who ruled in favor of Brown in the case Brown versus Board of Education. This case allowed desegregation in our public schools. It allowed children of all races to attend the same school together. Other notable justices include Thurgood Marshall, our nation's first African-American justice, and Sandra Day O'Connor, the nation's first woman justice. The Supreme Court is considered by many to be the guardian of the Constitution.